Hello, everybody. Today we are going to discuss relationships and marriage. It's going to be me, Tay, discussing Scalia's dissent.
I'm Adia, and I'll be talking about the family case study.
I'm Annie, and I'll be talking about Obergefell's Judge Rogers' dissent.
Cassidy, and I'll be talking about Justice Alito's dissent.
I'm Kendra, and I will be talking about the marriage case study.
My name's Lauren, and I'll be talking about the Obergefell's court opinion.
And I'm Madison. I'll be talking about the Winsador court opinion.
Okay, so first we're going to do the family case study. It was about a man, so Leslie Blanchard was a successful hairdresser in New York City, and he met Miguel Broschi, and they fell in love. Blanchard passed away in 1986 of AIDS and left Broschi his estate. So his landlord was angry about the rent control law of 1946, which prohibits landlords from evicting surviving spouse of the dead tenant or another family member that was living with the tenant. But so he began sending threatening letters in an attempt for Broschi to move out and claiming that he was not Blanchard's family and he had no right to the apartment. So some things that kind of affected this case were the AIDS epidemic was going on at this time. So 24% of New York residents were below the poverty rate in 1984. And so landlords were really upset about the rent control especially because a lot of people needed housing. And so they were Stahl was trying to get rid of Broschi because there were other people that could have paid better for the apartment. So AIDS caused the LGBT community a lack of attention from the government. The mayor of New York spent roughly $75,000 in AIDS-related public education, and San Francisco spent over $16 million, and they had fewer cases. So the LGBT community was really backing Broschi in this case and his team. After 2.5 years of the case, they won the case, proving that family is ultimately about love and caring and commitment rather than legal formality. So even though they weren't legally allowed to be married, they were still able to be considered family, and the landlord had no right to send him threatening notes to kick him out. So they left a long-lasting impact on the LGBT community, bringing recognition to committed same-sex couples living in rent-controlled apartments.
All right, so the marriage case study. So essentially, this article was about how, in the 1990s, Hawaii did not recognize rights to same-sex couples as other states did recognize some rights to an extent. And in December 1990, 3 same-sex couples planned and staged, a kind of like a showcase to show that, Hawaii did not recognize their right to get married. So they all went to, the marriage license, station and tried to request a marriage license, but they were ultimately denied, and this subsequently led to a lawsuit that would last for roughly about 8 years. So, and some other things that the article went over was that, same-sex marriage lawyers were not common, as law schools at the time did not practice or teach about that sector. And American laws criminalizing same-sex marriage goes as far as back as the colonial times, but American laws never explicitly excluded or limited same-sex couples. It was essentially the whole reason why we had the issue was that it came down to what was the definition of marriage and how it was defined by the court. So it was all up to interpretation. And these laws were never challenged until the 1970s, but the court ruled that marriage was defined as to be between one man and one woman. And so same-sex marriage was not a civil rights goal to LGBT leaders during this time, as it was split between ideological versus pragmatic, as some people didn't view it as it was a necessity, and lawyers fought that in the LGBT community to have the community focus as a goal, but it didn't go over so well until a lot later down the line, even past this case. And the Hawaiian same-sex couples in the lawsuit were denied help from organizations at first. It wasn't until about 1993 that the organization Lambda helped out. And Hawaii conducted hearings in 1993 on the question of whether same-sex marriage should be legally recognized, and the commissions that were set up were made to help make recommendations on how to handle the issue. As one commission said that they should overturn the opinion that was made before to make it between only one man and one woman, and then another commission made the recommendation that they should make it like at least give some recognition, but not to the status of marriage. And another thing that was pointed out in this was that there was other cultures outside of the U.S. that experience or practice homosexual activities without discrimination, as negative connotations of homosexuality, nor the vocabulary of gay identity were known. And one of these cultures that was highlighted was the African country of Togo, as men could live impeccable heterosexual lives with, a wife and children, but still be able to maintain a healthy sexual attraction to other men without believing themselves or labeling themselves as to be gay. Some of the tactics that the lawyers used were similar to the Loving versus Virginia case, which is the case that overturned the discriminations of interracial marriages. And essentially it all boils down to how the use of language is to find loopholes in the issues. But ultimately the case was dismissed as moot in November 1993, meaning that essentially the same-sex couples were not able to get married. And so the impact of the Bear versus Lewin case led to profound social and political impacts, and some of these were Americans were introduced to the conversation on LGBT issues, as it previously they didn't even really know any of the issues of what was going on. And these issues range from same-sex marriage and other issues in society. And then this also led to other states to have similar cases, and in some cases, positive outcomes. Just like a couple weeks ago, we learned about how Massachusetts was able to gain same-sex marriage in 2003, so that was like a positive outcome. And then, but also on the other side, many states enacted statutes making it clear that a valid marriage is only between a man and a woman, and would not recognize same-sex marriage if it was entered into other states. So meaning, if you did get married in a state that did recognize same-sex marriage, some states that did not want to recognize it will not recognize it.
So I'm going to be talking about the Obergefell summary, and there were the petitioners and the respondents. So the petitioners were 14 same-sex couples and 2 men whose same-sex partners are deceased. They came from Michigan, Kentucky, Ohio, and Tennessee, because their defined sense of marriage was a union between one man and one woman. The respondents were the officials responsible for enforcing the laws in question. So petitioners claim the respondents violate the 14th Amendment by denying them the right to marry or to have marriages lawfully performed in another state given full recognition. Under the Due Process Clause of the 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. So the court's opinion was based on 4 principles of tradition. The first one would be marriage and liberty. It was said that the right to a personal choice regarding marriage is inherent in the concept of individual autonomy. That kind of stemmed from the Goodridge case in Massachusetts. The second principle would be that marriage is fundamental. It is basically a right older than the Bill of Rights, which was stated, and it comes from the Griswold versus Connecticut case. The third would be it safeguards children and families, and it essentially comes from the right of rearing children and procreation and education. And it basically wants to make sure that children won't have the stigma of having parents unmarried and whatnot, and it allows a permanency and stability for children. And fourth would be marriage is the keystone of social order. So essentially, there wouldn't be any foundation of society without like the family and marriage. So there would be no civilization or progress that we've had. Some of the benefits that have been denied without having same-sex marriage equality would be from the states, and that would include taxation, health insurance, and adoption rights. Because same-sex couples are denied benefits given to opposite-sex couples, they're barred from exercising a fundamental right. This comes with the Due Process Clause and Equal Protection Clause, where rights mentioned in the Due Process Clause are protected in the Equal Protection Clause. So this has led to the conclusion, which would be the right to marry is a fundamental right inherent in the liberty of the person, and under the Due Process and Equal Protection Clause of the 14th Amendment, couples of same sex may not be deprived of that right and that liberty.
Okay, so I'm going to be talking about Chief Justice Roberts' dissent. And basically, I kind of pulled out the 4 main points of this. And they were just kind of like the driving themes behind the majority's arguments. So the first one was that marriage is desirable and the petitioners desire it, and they do not wish to demean or devalue this institution. And by that, it just means like they wish to keep respect for the institution of marriage, but they do desire same-sex marriage for themselves as well. And Chief Justice actually says that the compelling personal accounts of the petitioners and others like them is actually possibly a likely reason why many Americans have changed their minds about allowing same-sex couples to marry. But he says, however, as a matter of constitutional law, the sincerity of petitioners' wishes is not relevant. In the second majority driving theme, they said that there are other more instructive precedents informing the right to marry. And basically, he thinks that what they mean by this, they're actually referencing to a number of past cases which discussed the implied fundamental right to privacy. Cases like one where the court invalidated a criminal law banning contraceptives, or like the one that we actually read about last week, Lawrence versus Texas, which struck down the Texas statute criminalizing homosexual sodomy. However, Chief Justice Roberts says that these privacy cases provide no support for the majority because they do not seek privacy. Rather, they're seeking a public recognition of their relationship and getting married. And then the third majority driving theme was that expanding marriage to include same-sex couples could actually pose no harm or risk to themselves or third parties. So basically, like, them getting married, like, doesn't injure somebody, it doesn't murder somebody, it's just them getting married. And there's actually an interesting quote from his dissent, and it says that a justice's commission doesn't confer any special moral or philosophical or social insight sufficient to justify imposing those perceptions on citizens under the pretense of due process. He says that there is a process due to the people, and that's a democratic process. So respecting that requires the understanding that the court is not guided is guided by law, not by any particular school of thought. So basically, the assertion of the harm principle is more of a philosophy than an actual law. So he's saying that it can't really apply in court because of it being a philosophy. And then the last driving theme was that they kind of argued that there is a synergy between the Equal Protection Clause and the Due Process Clause, and that some precedents relying on one clause have also relied on the other, so they kind of just rely on each other to keep things in check. And he says that whenever they discuss this in court, this part of their discussion was actually hard to follow. And he says that absent from this portion of opinion is anything resembling the usual framework for deciding equal protection clauses. And then he goes on to state how the equal protection analysis that they had presented in court might have gone differently, and might have gone differently if they confronted the court with a more focused challenge to the denial of certain benefits. So if they had, like, instead of just challenging the overall general idea of being married, if they had gone on to target specific things, like specific benefits that they're being denied from being married, then it could have counted as an equal protection clause case. And so that's basically what his counter was.
So I'm going to be talking about the opinion of the court from the Winsor case. Some important background to know is that Edith Winsor and Thea Spire married after being together since 1963 in Ontario in 2007. New York recognized this as a lawful marriage. However, when Spire died in 2009, Winsor had to pay federal tax to claim Spire's estate, even though it was supposed to be inherited, as she was not allowed the federal estate tax exemption for surviving spouses because of the Defense of Marriage Act. Winsor paid the taxes, but filed a suit to challenge the constitutionality of Provision 3 of DOMA. Provision 3 of DOMA gives a federal definition of marriage and spouse. Marriage being a legal union in between one man and one woman, and spouse being a person of the opposite sex that is a wife or husband. However, this does not forbid states from permitting gay marriage. This is only for federal statutes. However, there's over 1,000 federal statutes that involve either immediate family or marital relations. So, this case got heard, and the court said that the Treasury had to pay Winsor back the federal taxes with interest. However, the Treasury never did that. On top of that, it was a very unusual case because the executive office, if I remember, yes, said that they would. What did they say? Wait, hold on a second, please. So the Attorney General, while the suit was still pending, told the House of Representatives that the Department of Justice would no longer defend DOMA's constitutionality. This was unusual because usually that type of letter was not preceded by an adverse judgment, but instead it reflected the president's own words. This was in 2009, so that president would have been President Obama. The Bipartisan Legal Advisory Group, which is called BLEG, of the House of Representatives, wanted to interfere with the litigation to defend the constitutionality of DOMA. However, they were denied on that basis, but were still allowed to grant intervention because they were an interested party. So this case eventually went on to the Supreme Court because it fulfilled all three requirements of Article 3. Winsor suffered injury by having to pay taxes while she was a spouse to gain her spouse's estate. There was a clear connection in between who was injured and who injured them. So the government in this case is the person or the entity that injured Winsor. And it must be likely that the injury would be redressed by a different decision. So in that case, it was allowed to continue on because whenever they went to court about it, likely that decision would influence more people than just Winsor. It was also important to do this because if it did not go on to the Supreme Court, close to 100 district courts would have had to deal with thousands of cases regarding having to pay federal tax and refunding that because of the federal state tax exemption. So having this precedent was really important. Eventually, the court did decide that that DOMA was unconstitutional because it discriminated, and its sole purpose was to discriminate against same-sex couples.
Important to give some background information on what kind of judge she was. So Judge Scalia was appointed by Ronald Reagan. Judge Scalia did tend to go more conservative in his ideologies within the rulings, and Judge Scalia really advocated for textualism and originalism during his interpretations of the Constitution. All right, then you get space. Okay, let me put this away. Okay, so in Judge Scalia's dissent, Judge Scalia believed that the Supreme Court had no power under the Constitution to rule upon this case. He believed that eventually Congress and the president should make this decision because of the popular opinion changing and people agreeing upon same-sex marriage more. Justice Scalia often referenced Article 3 of the Constitution, which, as Madison previously said, requires the plaintiff or appellant who has standing complaint but an opposing party who denies the validity of the complaint, pointing out that within this complaint there really wasn't much of an opposing party. They kind of agreed on, you know, the same thing of getting the taxes back, or the payment back. So that was another reason why he didn't think that it should have went to the Supreme Court, that Congress should overturn the law and pass a law legalizing the same-sex marriage. And Judge Scalia also stated towards the mid to end of his dissent, saying, place the Constitution's entirely anticipated political arm wrestling into permanent judicial receivership does not do the system a favor, once again reiterating his entire dissent where he believes that it should have been Congress or the president who had made this decision, and that they ultimately had no right or no power or authority over this decision, that it would have eventually have worked itself out within Congress. And that's good.
Justice Alito claims that Edith Windsor is seeking a holding that enshrines in the Constitution an understanding of marriage in which the sex of the partners makes no difference. And he believed that the United States was not the proper petitioner in the case. He argues that the Constitution does not guarantee the right to enter into a same-sex marriage, and that due process clause protects only those fundamental rights and liberties which are objectively deeply rooted in the nation's history and tradition. He also argues that changes in family structure and popular understanding of marriage can have long-term consequences. And the issue of same-sex marriage is not a judiciary case and should be left to the people to decide. He does not agree that Section 3 prevents any state from recognizing same-sex marriage and extending state right privilege, benefit, or obligations stemming from the state law. So the argument there was just that it was preventing federal rather than what the state does provide, basically.
All right.